In the complex world of construction, disputes are almost inevitable. From design flaws and delays to cost overruns and contractual breaches, things can, and often do, go wrong. When they do, resolving disputes requires more than just strong legal arguments. It calls for technical expertise. This is where the expert witness comes in. I'm Faye Williams, Director at Harris & Clarke Chartered Surveyors, and today we're diving into the vital role expert witnesses play in construction disputes, who they are, what they do, and why their input can make or break a case. Let's start with the basics. An expert witness is a qualified professional with specialist knowledge, skill, or experience in a particular field. In construction disputes, this might be a building surveyor, structural engineer, a quantity surveyor, a project manager, or an architect. Someone with deep practical knowledge of construction processes, standards, and industry norms. Unlike a fact witness, who testifies only to what they saw or did, an expert witness uses facts and opinion-based evidence. They're brought in to explain technical details, assess compliance with standards, and evaluate the actions or omissions of parties involved. Their role is not to advocate for one side, but to assist the court, tribunal, or arbitrator by providing independent, objective analysis. Expert witnesses come into play when technical issues are at the heart of the dispute. This is common in construction, where matters often involve complex engineering principles, contract interpretation, or the sequencing of works. For example, imagine a project runs significantly over schedule. Was it due to a contractor's mismanagement? Or were there unforeseen design changes that justified the delay? Answering that requires more than speculation. It requires technical analysis, and that's where the expert comes in. They are also essential in determining the value of works done, assessing damages, or identifying defects in construction quality. Their evidence helps decision makers understand the technical context and make informed rulings. So what exactly does an expert witness do? Their core responsibilities typically include reviewing documentation. Experts examine contracts, design drawings, project schedules, emails, reports, and other project records to understand the issues in dispute. Sometimes they carry out a site inspection. They may visit the construction site to observe conditions firsthand, especially if the dispute involves defects, safety issues, or site-specific delays. Analysis and opinion. Based on their expertise, they analyse the facts and provide a professional opinion. This might involve delay analysis, cost assessment, or evaluating whether a party complied with industry standards. And the expert report. The expert prepares a detailed report that outlines their qualifications, methodology, findings, and conclusions. This document must be impartial and based on evidence. Testimony. If the matter proceeds to litigation or arbitration, the expert may be called to testify. During cross-examination, they must defend their conclusions under pressure, demonstrating both their expertise and the reliability of their opinion. Importantly, expert witnesses owe their duty to the court or tribunal, not the party that engaged them. Not all experts make good expert witnesses. So what sets the best apart? First and foremost, credibility. The expert must have the necessary qualifications, experience, and professional standing in their field. A chartered surveyor or quantity surveyor, for example, carries more weight than someone with limited experience. Next is clarity. Construction disputes are already complex. The expert must present their opinion in clear, understandable terms, both in writing and orally. Independence and impartiality are non-negotiable. If an expert is perceived as biased or too closely aligned with one party, their opinion can be discredited. Lastly, resilience under cross-examination. A good expert can defend their opinion confidently, even when challenged by skilled opposing counsel. Construction disputes often go to arbitration rather than court. While the expert's role is largely similar in both settings, there are some nuances. In litigation, the expert's duty is to assist the court. They must comply with specific rules, such as those under the civil procedure rules in the UK, and the expert may face rigorous cross-examination in open court. In arbitration, the process is more flexible. Arbitrators may allow a more interactive format, such as concurrent evidence or hot tubbing, where opposing experts give evidence side by side, answering questions in real time. This approach can clarify differences and focus on areas of agreement. Regardless of forum, the expert must maintain independence, present reasoned opinions, and withstand scrutiny. In the end, expert witnesses are essential players in the resolution of construction disputes. They bridge the gap between technical complexity and legal clarity. By offering objective, informed, and independent opinions, they help decision makers reach fair, reasoned outcomes. Whether the issue is delay, defects, or cost, a strong expert witness can illuminate the facts and sometimes shift the balance of a case. Thanks for joining us today. If you're involved in construction or dispute resolution, understanding the role of expert witnesses isn't just useful, it's indispensable. If you'd like to find out more, please check out our other videos at harrisonclarke.co.uk.